Mic check. Can people remote hear me? Can you raise your hand if you can hear me remotely? Try this. Vina, can you hear me? Can I get a quick check for feedback to make sure I can hear you?
Can you hear me?
Good deal. Yes, thank you.
No. It's always pretty obvious. Steve, are we ready? Steve, we're ready.
Good morning. It's 9:01 on April 24, 2026. Call the Forensic Science Commission meeting to order. Item number 1 is a roll call. First, Dr. Patrick Bazzini.
Here.
Dr. Michael Coble. Here. Mr. Mark Daniel. Here. Dr. Stacy Mitchell.
Here.
Dr. Jasmine Craig.
Here.
Dr. Sarah Kerrigan.
Here. We've got an issue with this echoing.
Let me finish this.
Yeah.
Mr. Jarvis Parsons.
Here.
Ms. Erica Zemek.
Here.
All members are here in one form or fashion. Item number 2, did he correct it? Yeah. Item number 2 is regards reviewing and adopting the minutes from the January 30th, 2026 quarterly commission meeting. Is there a motion to approve the minutes? So moved. Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries. Item number 3 is the office administrative update.
You can see in the meeting materials an updated budget. There's no motions that need to be taken on that. We just provide the update OCA checks to make sure that it's all in line with the records that they have. We're happy to answer any questions about the budget. The other administrative items I would turn over to Lee because it's mostly about our transition to the ALIS application.
So we've fully transitioned all of the licensee applications to the ALIS platform now, and we're working on kind of tweaking and making corrections with the developers, and that's based on really helpful feedback from the community. So we're grateful that you all have been patient with us and providing us feedback and issues as you've gone through the application process, and we're still in the middle of that. So if you have things to report or changes you want, while we have the developers on the hook, we appreciate those.
And then our office is completely under construction. It's quite a mess in there, but I poked my head into the new space, probably against the rules, yesterday, and they put the drywall up, or the, what do you call that stuff, Jared? Yeah, it's drywall. They haven't done any sheetrock. They haven't done any they haven't done the tape and float part yet, but they're, like, it's an office with the setup that the architect said would be there, so that feels like progress.
So they put things where the architect said to put.
Yes, they put walls where the architect said the walls would be, so it's good. It's still gonna be a while. I think their plan is to turn it over to us in August. I was hoping to be ready for the July meeting, so you could all come up and see the new space, but chances are it's gonna be more, later in the summer. So we're excited about that because it'll be really nice, and there's even a small conference room that's gonna be up there, which will be great. So if you all have, calls you need to do for your day jobs or whatever, there'll be space for you to come and all that. So we're excited about that. We'll let you know. If it looks like it's gonna be earlier, if they finish ahead of schedule, we'll add that to our July agenda, but if not, it'll be October.
Item number 4, the complaint and disclosures. Mr. Daniel?
Yes, sir, Dr. Carr, we have a bit of a crowded agenda on this. We have 8 disclosures and usual amount of 11 complaints. Item number 1, disclosures is 2551. Comes from the Center of Human Identification. I think Dr. Cole and Ms. Emmett were going to recuse themselves on this item. And they had received a package of evidence. It had a couple of stains on it, one dry, one damp. They could not confirm the condition of the item of evidence in it, whether it was impacted by that. It only affected one item. They notified all the parties involved. Wasn't any testing on that item. And staff had reviewed the matter carefully and made a recommendation in light of the root cause review and also the corrective action. Everything had been satisfied with the further action to be taken. So if there are not any questions or comments, I would go ahead and make that motion to take no further action.
Motion's been made for no further action. Is there a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? No opposition, motion carries.
Which brings us to our second item, 26.07, from Swifts and Dallas. I think Dr. Bernard was going to recuse himself on this. It's an unfortunate situation. There was a licensee drug analyst that appeared to have falsified some credentials in connection with representations of having a master's degree that they actually did not have. Lab can review it carefully and make a determination she has violated the Dallas County Code of Ethics, also ANABS, and also our Code of Professional Responsibility 651.219. There were some issues with regard to persistence in some of the denial and request for transcripts that weren't really satisfied. The analyst has since designed in lieu of determination. Staff have reviewed the matter carefully and actually wanted to drill down a little bit deeper and find out with regard to whether it might warrant disciplinary action by the commission, which I concur with. And, if there are any questions or comments, I would make a motion that we accept it for investigation to see if it might warrant disciplinary action by the Forensic Science Commission.
Right. We have a motion for item 2607 to undergo further investigation. Do we have a second?
Second.
Okay. All in favor, say aye.
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 All opposed, say nay. Okay. The ayes have it, so the motion carries.
Which brings us to our next matter, is 26.08 from the Serological Research Institute. It's a fairly simple matter that the laboratory determined back in February that lacked a documented procedure for diluting or concentrating samples used in amplification. They realized they just failed to update the methods manual. The spreadsheet was implemented. They drafted a fix for the issue. It's fairly simplistic. It's been corrected. If there aren't any comments or questions, staff has made a recommendation to us, which I concur, that there's not a need to take any further action. So I would make that motion that we take no further action.
Motion's been made for no further action. Is there a second?
Second.
Second's been made. All those in favor say aye.
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 Opposed? Motion carries.
Brings us to our next item, 2614 from Bodie Technology. There were some questions with regard to DNA and the end game here. We probably need to table this, pending some responses to questions for some retroactive case review. But just for a quick summary, it involves some DNA testing and also testimony. There were some issues with regard to incomplete and incorrect explanation of DNA statistics, analysis, and databases. Also, some items where the prosecutor had either misled or made some misstatements with regard to the testing. It's inaccurate statements as to analyst proficiency testing as a confusing explanation. So, without going into great detail, it's probably best that we table this to get some response to some of the questions. We have to revisit it come July.
Just to give a little bit further information, Jared, feel free to jump in, but in this particular case, the lab issued an amended report. It was a case that involved multiple related individuals, and it was a higher order mixture, so knock was a difficult thing to figure out, which is one of the categories of cases for DNA that's the most challenging for the community in general. And in the review, after having amended the report, Bodie was gonna take a look to see if there was some way they could identify whether there might have been any other higher order mixtures with relatedness that need another look. So that's why we're tabling it to see what happens there. And we agreed on a window of time that would be the first place that they'd look at to see for Texas cases, because they do a lot of work outside of Texas, but they're gonna narrow it down to Texas cases, and then we'll have more information next time. Did you want to add anything, Jared?
Was that made in the form of a motion?
Yes, sir. I did want to make one comment. I noticed that the analyst received some additional training, and then Bodie issued a quote testimony correction report. I don't know what that is. You have a jury trial, you have the jury seated, somebody testifies in front of them, the case goes to verdict, and then we correct the testimony after the fact. If that's what they're doing correctly, that's inadequate, but that's my comment.
This is a very unusual situation. The case had gone through the guilt innocence phase, and the judge paused for punishment to allow the case to be brought to the commission and looked at, and allow Bodie a chance to see whether or not the concerns that were being raised by defense counsel were concerns that needed follow-up. And then they issued the correction, and then the judge, I think, granted the post. I don't remember exactly the posture or what the lawyer filed, but the conviction was vacated because of the amended report. So there was direct action in the case it was we've never seen a case where a judge pauses between the guilt innocence phase and punishment to get more information about the scientific testimony, but that's what they did in this case. And we have someone from the Travis County DA's office if you want to ask any more procedural questions of how it happened. Did I get that right? Yeah. So I think that Bodie did what it needed to do to make sure that the court had what it needed, and now the question is, are there other higher order mixtures with relatedness that needed a second look? Does that make sense? It was unusual. We've never had a case paused in the middle, well, not in the middle, but between those two phases for further evaluation of scientific evidence.
Dr. Murray, I'll restate that in better form of motion if we table this item for self-disclosure, pending responses to questions for retroactive distribution.
All right, a motion's been made. Is there a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
Our fifth item comes from DPS Austin. They had a gas chromatograph instrument they changed the column out on and installed the wrong size. I don't need to go into all the numbers that did it, but they since corrected it. They since communicated to all their labs that the existence of this issue, to be cautious in the future, not to allow it to happen. There were not a whole lot of cases involved way back in March of 25. 6 of 7 total affected cases, all of which were reanalyzed, and supplemental analysis reporting was done. Their seized drugs program coordinator distributed correspondence throughout all the labs. It appears they'll be more cautious in the future going forward. In light of the corrective action, the review of the case, if there are any questions or comments, I would make a motion we take no further action.
Motion's been made for no further action. Is there a second?
Second.
Second's been made. All those in favor say aye.
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 Opposed? Motion carries.
Brings us to our sixth item, 26.18, is from DPS of Waco. There was an analyst in the forensic biology DNA section that had some overtime to be reported, and it appeared that they may have falsified the report. Main concern of the issue was they had gone on to work at some other labs, one being Othram, the other being Swift in Dallas. And staff had recommended to us, which I concur, that we accept the self-disclosure for investigation and determine whether the initial conduct might, lack of self-disclosure might warrant this commission.
Yeah, I think just in abundance of caution, Dr. Barnard should recuse. So, Dr. Drake, can you take the motion on this, please?
So I would make the motion we accept it for self-disclosure for staff investigation with a view towards necessary discipline of this commission.
So we have a motion which has been made. Do we have a second?
Second.
Okay. All in favor, say aye.
Aye.
Any opposed, say nay. Okay, the ayes have it, so the motion carries.
And that takes us into our always existing section of missing impact of recorded evidence disclosures. And first was 25.76, is from Center for Identification. I think Dr. Coleman, CMAC, whatever they accuse themselves, is that correct? They had two evidentiary items they had received from a police department in their area. They had actually returned the items to, I think, the sheriff's office by mistake. Both items were promptly transferred to the appropriate police department. The items covered 6 cases and totaled up 8 evidentiary items. They found an issue in the LIMS system that is going to be corrected and initially track the evidence in the future. Their corrective actions are creating a new agency type program within their LIMS system to designate inactive points of contact. They're going to remove unnecessary historical contact information from case records. They're going to target some training on the LIMS agencies tab and conduct a refresher training program. It looks like they've addressed the issue satisfactorily. And if there are not any questions or comments or concerns, I would make a motion that we take no further action consistent with staff's recommendation.
Motion's been made for no further action. Is there a second?
Second.
Second's been made. All those in favor say aye.
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 Opposed? Motion carries.
The next item is 26.16, and comes from DPS in Garland, seized drug section. They had received there at the lab 2 items of evidence for the same offense. One was plant material, the other was vape oil. During the intake process, the evidence technician did not follow the required intake process in separating the items. We submitted in the seized drug analysis for 2 separate lab cases, one for the plant material, one for the vape. Inadvertently, the felony case vape was mistakenly destroyed pending analysis. The cases subsequently were dismissed. All of this is the lab council employees involved regarding appropriate procedures. They've taken corrective action as recently as February this year to try to avoid such occurring in the future. And in light of their analysis of the issue and the corrective actions taken by the lab, staff have brought forth a recommendation to us that we not need to take any further action. I concur with that and make that the form of motion unless there are comments or concerns.
All right. Motion has been made for no further action. Is there a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
And that brings us to our complaints. And the first was item 2529, which is somewhat multifaceted. It has a number of individuals being complained against, a number of different processes and labs also being complained against. I believe Ms. Emmett is going to recuse herself. Is that accurate?
Yes.
And it comes from Gretchen Swain, an attorney who's representing Captain Bird and Lieutenant Blake Ward. He had been convicted in the murder of 2 individuals, and then in punishment phase there were 3 other homicides and murders for which evidence was introduced, and there were complaints that covered the entire gamut from the guilt innocence phase to the punishment phase. The first complaint focused on Ron Smith and Associates. The second, the Houston Forensic Center, Science Center, also analysts Sandy Siegel and Steve Vinson, Robin Gidry, and Courtney Head. With regard to Ron Smith and Associates, it stemmed from a print found on a pair of eyeglasses. It alleged that Smith had signed the report without conducting the analysis, which was performed by an analyst, John Schwartz. It was also verified by 2 other RSA examiners, contract examiners. The complaint also alleges that the commission had discredited Ron Smith's work in an investigative report back in 2022. That is not entirely accurate. We did not discredit the actual work, but rather made some observations regarding the need for better documentation in future cases. We did not issue a finding of professional negligence or conduct against Ron Smith. And I'd like to comment here, this complaint has so many different individuals and complaints that we can dismiss all of them, or we can accept it and narrowly authorize the acceptance for one individual and one analysis. But with regard to Smith, staff had indirectly made a recommendation that since there was no finding of professional negligence against Ron Smith, there wouldn't be need to do anything but dismiss that accusation, that claim as part of the complaint. We take that up individually at the time we make the motion. The next is analyst Sandy Siegel, and it pertained to the Lewis crime scene prints. It said that Siegel evidently had already known these conclusions and literally accepted the work from Ron Smith and almost put it through a copying machine. Staff went to great lengths to actually interview all the examiners in connection with this and found out that there were certainly some gyro annotations in the comparison made by Siegel that were not done by Smith earlier. There's no indication of her copying that analysis report, and they had directly recommended that we dismiss that portion of the complaint also, and the rest of that can clean up the item. As far as the DNA analysis allegations, there were a number of individuals, a number of different aspects, but most of it pertained to a Robin Guidry at HFSC. She was complaint alleged that she had engaged in professional negligence and misconduct in her forensic analysis by misusing CODIS, handling some degraded hair samples, caused the facilitation of some misleading YSTR by Cellmark, testified to misleading star mix results, and also relied on work by former analyst Stephen Benson. And so let's take up each of those individually. The misuse of CODIS, she had created an item of right fingernail scrapings from the victim. It resulted in a one-time CODIS hit to Ward back in 2010. We got to follow the chronology. That's 2010. In 2016, there were changes in DNA mixture interpretation protocols, and the lab amended that report to provide that the item contained insufficient data for comparison. And then the complaint asserts that the CODIS association should have been withdrawn at that time, and then claimed the CODIS hit must have originated from a biological sample, which is really not supported by any data. The complaint claimed our review of the case showed the CODIS upload and hit were conducted according to protocols at the time. It's kind of hard to comply with something that occurs in the future. And arrived at a conclusion, staff arrived at a conclusion that Guidry did not commit professional negligence, which I concur with, and I'll be prepared to make that motion here shortly. And then with regard to handling degraded hair samples, there was some related testing on some degraded hair samples in the Rodriguez case. That was one of the guilt and innocence matters, if I recall correctly. Yes. And Guidry did not test the samples or testify regarding them. The testimony was done by Courtney Head. We can't very well hold Ms. Guidry responsible for professional negligence on something she wasn't even tasked with doing. So I will bring forth the recommendation that also be dismissed. The third item is facilitating misleading YSTR testing by Cellmark. Complaint alleges that Guidry forwarded evidence to Cellmark for testing and false her for not identifying deficiencies in Cellmark's methodologies. It's unfounded because she did not conduct the YSTR analysis, and outsourcing testing to another lab in and of itself doesn't constitute negligence or misconduct on a professional level. So I'll be bringing a motion shortly to dismiss that. Fourth item is misleading Starbucks results that pertain to the ICAL case, which was a punishment case. It claims that Gidry improperly applied unsupported assumptions in using Starbucks on a complex DNA mixture and testified that the board could not be excluded as a contributor. The analysis estimated typical numbers of 32% contributor and likelihood of 55 quintillion. It was reviewed by our staff program coordinator of all her notes, her reports, her StarMex of her testing, and they found no issues with the interpretation. So I'm going to bring forth the recommendation that also be dismissed. And then there's a timing issue. Part of the complaint alleges that Gidry relied on work from Stephen Benson. You may recall that from 2022. Some of the members of the commission may not have been here in 2022, which we recommend, but that involved a case where some evidentiary items had come into the lab and had not been refrigerated properly. They were found in a soil condition with a foul smelling smell coming from the cooler. And then there was testimony at trial that there's nothing awry or nothing wrong with the evidence. My recollection was a 60-day suspension, am I correct? In 2023, we did that.
Right, it went to the end of the licensing period.
Right. So with that being said, Gidry's testimony on StarMex results was in 2020, and that's important because we didn't even receive the item concerning Mr. Benson until 2022, and findings weren't made, I think, until 2023. So unless she has the gift of prophecy, I don't know that we can assign misconduct or negligence to that. And I'm also going to make a recommendation that that be dismissed. And then next, the complaint moves to Stephen Benson. It alleges that he created a new known reference sample for Mr. Ward by splitting an original reference sample. It was item 23.1, it came out in 23.2. And then it just blankly says there was no reason for doing so. It cites our final report in 2218 of Benson. I just mentioned that there was misrepresentation in his testimony. Logging out a container doesn't establish he committed some negligence or misconduct, so I'm going to bring forth the recommendation to dismiss that also. So, lastly, the complaint focused on Courtney Head at HFSC, and it alleges at the time of his trial, she testified analytical results generated by other analysts in multiple laboratories, and the word could not be excluded. The complaint speculates that some of the hair may have been switched and doesn't really give any evidence to support that claim. And then part of the claim is that violated the right of confrontation, which is an issue for the court, not for the commission. There was no indication or evidence the samples were switched, and staff made a recommendation that portion of the complaint be dismissed. So, multifaceted, yes. I'm going to respectfully make a motion that we dismiss the complaint because all these allegations failed to establish negligence or professional misconduct. If any member of the commission wants to bring forward one of these matters for investigation of what I count to be 8, we could separate that out and accept the complaint on that narrow basis alone. Any comments, questions, or thoughts?
Yeah, I would like to make a couple comments. One is a technical one. Can y'all hear Mr. Daniel are you having a hard time hearing him? Should he move? Maybe you could move the lapel mic a little bit further, sorry. Or can you hear him better now?
Hello.
Is that better? Yes, Patrick, okay. If you have challenges hearing him, you can just put it in the chat. We'll try to bump up the mic. I wanted to say that this was challenging because when we first received this complaint, it basically just had the writ attached. And so I would put a respectful request out there to the community of people who file complaints with us to please try to not do that, because we cannot sort through a writ filing to try to figure out which aspects of it may have any jurisdiction with us. So we need people who file to narrow the issues down to the best of their ability. I will say though, that even when the complainant had done that, it still, as you can see, it took Mr. Daniel a while to get through the various items, but staff really worked hard to try to figure out what's being alleged, and it was Robert and Jara. You know, Robert handled the Friction Ridge piece. He had also worked on the previous Ron Smith matter from a few years ago, and Jara worked through all the DNA stuff, and they did a great job and worked very hard with the lab to try to make sure that they were understanding the case records. It was the first Star Mix case, so you know that required some review, and also the allegations related to Mr. Vincent, understanding how they pulled evidence and the container-based system that I think since then has changed. So I did want to give either Robert or Jara an opportunity to add anything to Mr. Daniel's presentation, but I think it was very thorough and clear. Did you all want to add anything else? No? Except that the lab did a really good job of working with us multiple times to make sure we were understanding everything in the case record. Did you all want to add anything from HFSC? No.
If there are no further comments, I'm going to make a motion to dismiss the complaint with failure to adequately allege professional negligence misconduct. I'm going to name all the individuals: Ron Smith, Siegel, Guidry, Vincent, Ford, Head. And I make the motion with the caveat that any member of the commission wishes to accept it on one narrow item, you can do that. So that's my motion.
All right, motion's been made as described by Mr. Daniel to dismiss the complaint. Is there a second?
Yeah.
Second, it's been made. All those in favor say aye.
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 Opposed? Motion carries.
And that brings us to our next complaint, it's 25.74, brought by Antoine Smith against Swift. I think Dr. Bernard was going to recuse himself in connection with this matter. There was a case where the crime scene detective testified to swapping a trigger and also a trigger guard on a recovered weapon. That was a little bit different than what the report reflected, which detailed the swapping of the trigger guard only. And there was some genetic testing done on that. There weren't any concerns with regard to the DNA analysis or related testimony. The complaint didn't really allege negligence or misconduct on a professional level. It was more of an issue with regard to asking us to have somebody execute an affidavit, which we really can't do. So the laboratory actually didn't collect the evidence either. So the staff had reviewed it carefully, and as did I, and I'm prepared to make a motion to dismiss the complaint.
Mhm. We have a motion to dismiss the complaint. Do we have a second?
Second.
Okay. All in favor, say aye.
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 All opposed? Motion carries.
And that brings to our next item, 26.01. It's from an organization called the Narrative Project in Houston. It's filed by Jacob Newsom with the Narrative Project. It's on behalf of defendant Louis Luna. He was convicted of capital murder with the death of his daughter. The complaint alleges the lab reported the presence of some unidentified male DNA recovered from the child, but the records actually show there was no documented follow-up testing, no CODIS, no comparison on that sample. the complaint request, the commission determined whether all the forensic procedures and reporting obligations were undertaken. The lab provided the commission a fairly detailed response of all 27 evidence items tested. There was one unattributed single source mail profile that was obtained from a sample at the scene. They compared it to all the reference samples and excluded. Been entered into this profile been entered into CODIS some 5 years earlier. Staff had made a recommendation we dismiss the complaint. It really failed to allege professional negligence or misconduct related to forensic analysis or any physical evidence, and also the thoroughness of the lab's response. So I'm here to make that form of motion unless there are questions. And I'll make that form of motion, Dr. Ron.
Motion's been made to dismiss the complaint. Is there a second?
Second.
All those in favor say aye.
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 Opposed? Motion carries.
Brings us to item 26.2. It's from Melvin Paul, concerns the Houston Forensic Science Center. The complaint was there was no evidentiary hearing in the case. There were several areas of non-compliance with DNA lab supposedly established by the FBI. There was reference to the Bromwich investigation from years ago in Harris County. This case wasn't part of the Bromwich investigation review panel. Nonetheless, staff felt like it's something that can be treated as a request for DNA mixture review and referred it to the Harris County Public Defender's Office. I concur with that. And I would make a motion to refer this matter, this complaint, to the DNA mixture review team.
Motion's been made to refer to a DNA mixture review team. Is there a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
And that brings us to our 13th item today, 26.3. It's by James Floyd, it's for the Police Department Crime Lab. Floyd claims an analyst testified at trial that he could not be excluded as a contributor of minor types detected from a mixture from a left pocket of genes. He questioned whether interpretation was correct. The Commission's scientific program coordinator obtained and reviewed the relevant data from the lab, including electrocardiograms, notes, comparisons, and statistical analysis. And while neither the lab report or the analyst testimony mentions a comparison to the victim, current lab administration presumes this is based on opinions of mixtures from two males that would actually exclude the victim based on their gender alone. In light of that, staff had made a recommendation to dismiss the complaint following a fairly thorough review of the lab report, the documentation, and the expert trial testimony, which I concur with. I'll make that in the form of motion to dismiss the complaint.
Motion's been made to dismiss. Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
And then that brings us down to 26.06. It's also a matter, item from the narrative project. It's against the Montgomery County Sheriff's Office Crime Scene Department. It's on behalf of a defendant, convicted defendant, Antonio Armstrong, in requesting a complete review of the forensic methodology used by the lab in this case and make sure it's not involving some aspect of professional misconduct. The complaint requests clarification of timeline regarding the home alarm system and also the shooting reconstruction analysis. According to the published reports, the defendant was convicted back in 2016 of murder of each of his parents. There was testimony in the case regarding the home alarm system offered by an alarm expert. We don't have a lot of jurisdiction over alarm systems. Regarding shooting reconstruction, the complaint alleges the conclusions offered at trial were expressed almost with near certainty as to angle of fire and distance determination. Those matters were undertaken by the medical examiner's office, another area we don't have jurisdiction over. So staff had made a recommendation, we dismissed the complaint. Then we don't have jurisdiction over private alarm systems, and also testimony regarding shooting reconstruction done by a medical examiner's office is outside of our scope and jurisdiction, so we try to stay in our lane where we can. And in light of that, I make a motion to dismiss.
Any discussion? Motion's been made to dismiss. Is there a second?
Second?
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
And that brings us to item 2611. It's also brought by the Narrative Project in Houston, concern from Montgomery County Sheriff's Office. Convicted defendant was A.J. Armstrong. He had some concerns about the crime scene reconstruction. It alleges that there was some undisclosed prior misconduct by the crime scene reconstruction analyst. It says that the Texas Forensic Science Commission had made a complaint against this analyst, previously accusing her of planting evidence. That complaint, as you might recall, was dismissed at the time as being outside the commission's jurisdiction. Staff at least shared with the complainant in this case that we have access to our records and public information. You get them one or two ways: one through a database, number two through a Rule 12 request, which is the same thing as a PIA request. It's simply we're a judicial body and we have to use Rule 12 as opposed to PIA that read almost identically. The accusation involving the crime scene reconstruction person was dismissed back in 2019. Finally, it alleges that the DNA analyst, Rochelle Lawson, was terminated at the Houston Forensic Science Center in 2024 due to some work issues. The Armstrong case was litigated and tried way back in 23, so issues with Rochelle Lawson were not known at the time of the trial. So again, we don't have the gift of prophecy. Staff made a recommendation. We dismissed the complaint regarding allegations pertaining to prior misconduct by the crime scene reconstruction analyst. Because they were publicly available and could have been obtained routinely. And then the analyst named the complaint was terminated for work well after the defendant's trial, which makes sense. So I'll make that in the form of a motion to dismiss.
Motion's been made to dismiss. Is there a second?
Can I just say that this mainly goes to what was disclosed in the context of the criminal case, and those discovery questions are also outside the commission's jurisdiction. So, just to be clear, a lot of it's about discovery disputes.
All right, is there a second?
Second?
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
That brings us to our next item, 2612. It's brought by the National Innocence Project. It concerns 3 people in the medical field concerning testimony regarding bite mark evidence. As many of you know, there's been some findings by this commission many years ago concerning bite mark analysis. I was notified by our general counsel just prior to the meeting that it might be appropriate that we obtain transcripts and see precisely what was testified to before we take any action on this. In light of that, I would respectfully make a motion to table this, hopefully bring it back in July and we can resolve it at that time.
Motion has been made to table the complaint. Is there a second? Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
And lastly, our item 2613 was brought by Ms. Colleen Massey against Harris County Institute of Forensic Science, their crime scene investigation section, and also some autopsy issues. The allegation medical examiner made a quick self-inflicted gunshot wound assessment at the scene, and they Massey challenged the thoroughness of that investigation. She pointed out there wasn't stippling, soot, or unburnt powder near the exit or entry wounds. According to the complaint, there was 10 fired and unfired rounds left the scene that should have been collected. We're not regulating or overseeing evidence collection at a scene. So staff made a recommendation we dismiss this because we don't have jurisdiction over findings by a medical examiner. And if there's evidence regarding mishandling crime scene evidence, who's a member of the medical examiner's staff and office, we're not responsible for that. And I think usually the police department actually process the crime scene. So in light of that, I would expect to make a motion that we dismiss item 2613, complaint number 2613.
Motion's been made to dismiss. Is there a second?
Second?
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
And then we always give blessing to administrative staff dismissals, and I would refer your attention to item 2612 and 2613, complaints made by the National Innocence Project on, again, on a bite mark issue, and also, I'm sorry, I have it wrong, it's 2604 and 2605, I'm sorry. 2604 involved the Associate Director, Center for Human Identification, against the director of that facility, and staff had dismissed that administratively, which I concur with. And then item 2605, it was a failure to allege professional negligence against the warrant. The county district attorney's office lost a case file and associated evidence from a case some 38 years ago. So I would respectfully make a motion that we give approval to the administrative staff dismissal of 26.04 and 26.05. That's a motion.
We need a recusal on the first one, so I would separate them.
Let's go 2604. I think Dr. Cole is going to recuse himself on that.
That's
Okay. So I make that motion, it's 2604, to give approval to that administrative dismissal.
The motion's been made. Is there a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
Likewise, this is 2605. I make a motion to approve that administrative staff dismissal.
Motion's been made to dismiss the administrative dismissal. Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries.
I think that completes our complaints and disclosures items.
All right, thank you, Mr. Daniel. Agenda item number 5, the Crime Laboratory Accreditation Program.
For agenda item 5, first we'll summarize the accreditation activities. You all have before you consideration of 7 different accreditation related items this quarter. 4 of them were full reassessments for accreditation that were granted. 1 was a scope change, and 1 is a reported accreditation nonconformity. And 1 was an annual review by A2LA. Does anyone have questions about those items? B here is the proficiency testing memorandum that we review each quarter, and it's drafted by staff. The commission has 23 of those items that are reported PT nonconformities or unexpected results reported from laboratories for consideration. Those were handled in depth this quarter by our scientific program director, Jara. And I'm not sure that there's any follow-up on any of these. Did anyone have outstanding questions related to any of them? Okay, thank you. And then C here is a rule adoption that exempts from accreditation requirements any forensic analysis that's performed on non-lethal munitions. And you guys saw this at your last meeting, but typically devices commonly used to either incapacitate or deter folks without causing permanent injury or death by law enforcement. So right now, no accredited labs offer this specialized type of testing, so we chose to propose that we exempt this type of testing for the benefit of both prosecutors and defendants so they can use the technology and testing. And this is the rule adoption from our last meeting for that.
Any discussion? All right, is there a motion to adopt rule amendments as discussed, subject to suggested non-substantive revisions from the Office of the Governor, Texas Registering Commission staff?
I'll make the motion.
Motion's been made. Is there a second?
Second?
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries. Number 6.
Agenda item 6 relates to an update for our licensing program. Currently, we have 1,390 total licensees. We have 15 new licensees since our last meeting. Quarter-over-quarter increase is about 1.1%, and that's a steady increase. We continue to grow as a licensing program. The total new licensees that we issued, just to give you all an idea, this fiscal year has been 76. And when we predict for our budget, because this is a revenue generating program that we finance the program through the revenue, we typically predict about 50 and we're at 76 after just 2 quarters. So interesting fact. Some of the items from yesterday's meeting, the licensing advisory committee met yesterday with staff. Some key things that were decided there, they recommended a rulemaking that we'll consider in item F here on this agenda. They also discussed the rapid DNA operator or collector potential license parameters that we might develop there, and we'll discuss that one later on in our agenda. Staff reported on the status of the General Forensic Analyst licensing exams, 3rd iteration, and for that, we've hired the psychometricians, we've engaged them and had an opening call with them, and they're now helping us solidify all the study materials and make sure they align with the objectives appropriately. So we started that process with a goal of projected release of the new exams sometime in early 2027. Item C here is for the commission to review any recommended coursework or criminal history considerations, and we don't have any this quarter. D is a report on a course that was held in Austin that I think we have 3 members that are part of that subcommittee that are gonna give a report for us, Shelley and Ashley and Michelle.
So Elise. So we decided to, in order to help with the voluntary license for crime scene investigation, one of those components is that your agency has to have a standard operating procedure. In talks with CSIs from around the state, we realized that unless you come from an accredited lab, a lot of agencies don't have an SOP. So we decided to take a step back and offer a SOP development course for crime scene investigation. It was held here in this building. We allowed for the morning to travel, so we started at 1 o'clock on Monday, and we concluded Thursday afternoon, right on the heels of Good Friday. We had 9 students in attendance. 5 of them were from police departments, 3 were from sheriff's offices, and we had a constable's office. Those agencies range from Central North Texas, the DFW Metroplex, the Austin area, the Houston area, and South Central Texas. So we had a really nice representative from kind of our side of the state. Some of the feedback that we got, that we received, is that the students wish they had a full 5 days. We thought that being locked up in a room together for almost 4 days was going to be enough, and the unanimous consensus was they wanted a full 5 days. They have since requested that we do additional crime scene management classes. Several of the attendees asked if they could come back to the next class, and I kind of inquired why, because they've already written an SOP, CSI SOP, but now they want to start working on other discipline SOPs. One of the students said that The work that he got done in the days we were together, it would have taken him 2 years at his office to get that done. Michelle and I divided up the review of the SOPs. Some of those were coming in towards the end of the week, and so we were able to go through, review, make recommended changes, and give them back. One agency has already met with our command staff for approval of the SOP that was written. We have had, Michelle and I have had meetings with these attendees on our recommendations, kind of eliminating the poison words, just highlighting what is still missing, especially the stuff that is required by the commission. So moving forward, I think this is something that we would like to continue to do for the forensic scientists across our state. We have a spreadsheet, so as people are asking to be part of that class, when we get a minimum, about 10 students, then we'll go ahead and schedule the next class, and we will continue that process until either everyone has a functional SOP or until there's no longer a need. Thank you.
Thank you.
Agenda item 6E is a rule adoption that you all proposed at the last meeting. And this one addresses the Code of Professional Responsibilities applicability to crime laboratory managers working in accredited crime laboratories only. And it makes it clear that this section doesn't apply, obligations don't apply to unaccredited forensic science service providers that might have employees who are voluntarily licensed, for example. So we're asking you all to make a motion to adopt this rule.
Is there a motion to adopt rule amendments as discussed, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register, and Commission staff?
I'll make the motion.
Is there a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
F here is a rule proposal that you all haven't seen before. It's recommended by the licensing committee, as we discussed yesterday. What we're doing here is, if you all recall, we have a waiver of certain coursework or education components for any type of license, any license discipline that's mandatory, where either the person can be certified by a certain agency that we have listed and specified in the rule, or they can have a certain number of work experience years, which right now is 5 total years across all disciplines. And then in addition to one or the other of those, the person has to have specific laboratory sponsored training during that 5-year tenure or whatever employment tenure they have in the area that they're seeking licensure. And so in this proposal, we're asking to reduce the term for work experience for firearms examiners only from the current 5 to 3 years. And this is based on feedback from the forensic community that 3 years is probably a sufficient amount of time to fill any gaps in education or coursework in that field. We haven't explored any of the other disciplines. We did talk yesterday, and we got a directive from the Licensing Advisory Committee for staff to look into whether the work experience years should be lowered for any of the other disciplines. So we're planning to do that, if you all are okay with that. But today we have before us just the rule proposal related to firearms examination, license only.
I have a question. When it says from 5 to 3, is this 3 years of actively doing analyses, or does that include a year to 2 years of training and only possibly 1 year of actually analyzing?
I think it's the latter, Dr. Bernard. I think it's the full tenure of being exposed to, because we don't specify in the rule.
And they have to do, they're doing supervised casework for a period as well. This was feedback we got first from the Houston Forensic Science Center, and it allows them to sort of evaluate the person to make sure that they're going to be a good fit. So it's a long enough period for them to get a sense of whether they can do the job, but not so long as to be a barrier for potential good hires. That's what they're.
Okay. All right, is there a motion to propose rule amendments as discussed, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register, and Commission staff?
So moved, Dr. Carter.
There a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries.
For item G, agenda item 6 is a report on licensing issues identified. We don't have any this quarter that were reported by laboratories.
Item number 7.
Agenda item 7 is a rule proposal that simply changes the title of a section so that it comports with the rest of what we're actually doing procedurally. The title of the section says investigative panels, whereas in one instance, we might appoint a panel, but we also have the authority for staff to investigate. So we just changed the term to investigative procedures, and it's something that I should have changed when we made those changes long ago, but just didn't catch.
Okay. Is there a motion to propose rule amendments as discussed, subject to suggested non-substantive revisions from the Office of the Governor, Texas Register, and Commission staff? Motion's been made. Is there a second?
Second.
Second's been made. All those in favor say aye.
Aye.
Opposed? Motion carries. At this point, I have been asked to take a 10-minute break, so we will start back up at 10:15. Back on the record, 10:15 and 4:24, 26. Item number 8.
Item 8 is the review and possible adoption of a final investigative report on self-disclosure 25.66 from SWIFT's. Dr. Barnard will recuse on this, and Dr. Drake will take the vote when it's time. Can you actually, Steve, change the view so we can see Dr. Drake? And, yeah, thank you. Yeah, we just need to be able to see her clearly. Okay, great. And Jara Kennedy is going to go through the slides that summarize the report that is in your materials. If we can get the clicker to work. You can say next slide if you want, Jara.
Yeah, I was gonna go backwards, but that's probably what we're gonna have to do here. Okay, so just give a quick rundown on this one through slides. They're also present in Govinda. So you can follow along if you wanna do that on your own. So this is a self-disclosure out of the Southwestern Institute of Forensic Sciences. So go ahead and go back.
It's working now.
Okay, for you or for me? Because I didn't touch it. So this self-disclosure concerns a DNA analyst, Kenneth Balgot, who's been licensed since 2019. And he was a current licensee until May 31st of 2026 coming up. And just so that you know, his license would have been or was on inactive status at that time since October 16th, 2025, because that is when he was let go from the laboratory. And so SWIFT disclosed this analyst intentionally altered a record of DNA testing in a criminal investigation, essentially to remove any evidence that there was contamination or a minor profile in a known reference standard, which is something that is directly collected from an individual and is used for comparison purposes. So the analyst was processing a batch of known standards together, and of one of those samples on that set had a case that was going to trial. So how this ended up being caught was that an analyst peeked at this batch to kind of get a look at what was going to happen with her case, because she knew that this case was going to trial, and noticed that her reference in particular was a mixture. And initially at that point in time, we thought that maybe it was due to this analyst himself, Ken Balgot, contaminating that sample. Investigation later revealed that he was not the source of the contamination, because SWIFT did a very thorough internal investigation on this case. And so what happened here was staff had a little bit of an idea that there was a contamination event, didn't think much about it, figured the analyst would come to them. And so when the analyst submitted the hard copy packet for technical review, there was no mixture any longer in the sample. That, of course, raised some flags, and essentially what we ended up finding out, or SWIFT did through their investigation, is that this profile was altered using Adobe Photoshop to remove or reduce the presence of any of those minor peaks in the profile. So, of course, immediately once they figure out that the contamination wasn't disclosed and that there was a discrepancy between the raw data on the instrument itself and then the printed out hard copy electropharogram or series of peaks for that individual, they needed to have a discussion with him. And he essentially admitted right away that he had altered the record to make it look like it was a known. He did not want to make it appear as though, he was incompetent. He had been going through some retraining, and it just felt like he couldn't make any mistakes. And so, but he also through this denied any prior alteration, that this was the first time that he had done anything like this before. And he decided not to interview with us. So all of this information really comes from the investigation that was performed by SWIFT. And so what we found through reviewing all of the documentation and having discussions with the laboratory personnel and management at SWIFT is that the analyst did commit professional misconduct when he intentionally and deliberately altered these records for the purposes of concealing a potential contamination event. And thereby violating several provisions of our Code of Professional Responsibility to include tampering with evidentiary materials, and then failing to conduct fair and unbiased examinations, failing to make and retain full, clear, and accurate written materials, failing to base conclusions on procedures supported by data, failing to present accurate and complete data, failing to communicate honestly and fully with all parties, and then failing to document and notify management of an adverse event like this with contamination. So the discipline, in conclusion, our disciplinary action here was that the license was suspended until the end of the active period, which is May 31st, 2026, which is when it will expire, and that we will also deny or refuse to renew the license for 5 years, and that we may impose conditions on the licensure at that time should he reapply for licensure in Texas.
And just to pause for a second, we do not do indefinite revocation. That's not something that's looked on favorably with occupational licensure. There needs to be a time frame around this. My understanding is that Mr. Balliot was eligible for retirement, so we don't have an anticipation that he's going to try to reapply at any Texas labs, but this is probably the harshest time frame we've imposed to date.
Robert, do you have anything to add to that? Okay. So as you can imagine, even though the individual says that they did not alter any records previously, the laboratory still had an obligation to go back and do a retroactive case review. And so they did that. All of the 208 cases that this individual had worked since his last contamination event were evaluated, and there were no issues outside of this current case that we're talking about today. SWIFT's notified their DAs immediately. No incorrect report was issued because this was caught during technical review before the report was released. And then another analyst was assigned to basically finish the case, document the contamination event, and each one of those records associated with this batch. The root cause analysis, of course, is there's analyst misconduct, but the laboratory chose to, you're probably putting the pieces together here about the discrepancies between the raw or the electronic data from an instrument, which would be almost impossible, I would think, to falsify a record like that, as opposed to how the laboratory was doing their technical review processes with a printed out electropharogram. So one of the corrective actions the laboratory instituted here was, going forward, there will be a review, and for any previous cases, anything that's going to trial is going to have a subsequent review to look at the raw electronic data versus the printed out electropharograms, as well as all of the other documentation in the case to make sure that it's accurate. And that's it. Any questions?
So the DA's office was notified, but we do not know if they are seeking an indictment on said person.
We asked and we don't believe they are. Because we don't believe so, no. Not to our knowledge. Any other questions? Discussion? Dr. Drake, I think it's up to you now. Can we actually expand the humans for now? Let's not put the next one up until this vote has been taken. Just so we can clearly see so that everyone in the room can clearly see all the commissioners and their votes. Dr. Drake, you can take over from here.
Okay, thanks. So staff has made a recommendation to adopt the final investigative report from the self-disclosure 25.66. Can I have that in the form of a motion?
So moved.
Second.
Okay. All in favor, say aye.
Aye.
All opposed? The ayes have it, so the motion carries.
Thank you, Dr. Drake.
Item number 9, Jefferson County.
Yes, Mr. Smith is going to go through a slide presentation that summarizes the draft report on this item that's in your materials.
All right, this disclosure comes from the Jefferson County Crime Laboratory concerning a seized drug and forensic biology screening analyst that's licensed by the commission. Her license was placed on inactive status October 17th. That's the day she was dismissed from the laboratory. And her license actually expired January the 31st of 2026. The disclosure alleges that the analyst had been involved via electronic messaging with a federal inmate who was incarcerated for trafficking methamphetamine. And additionally, she had sent monies to his commissary account as well as the commissary account of 5 other inmates. The laboratory determined that violated the Jefferson County Sheriff's Office policy and the written policy of the crime laboratory, and she was terminated the day that they became aware of these facts. The disclosure alleges her conduct constituted a conflict of interest and professional misconduct. We reported the investigation from the Jefferson County Sheriff's Office, who investigated the issue. They gave us a series of email messages between this analyst and the inmate she was messaging, and an accounting of the commissary donations that were made to these various inmates. The total was $2,030. From the laboratory, there's no evidence that this analyst committed any crime. Don't believe that she'd actually ever met this person in person. There's no evidence that any casework was affected by her actions. And the laboratory searched their records for any case involving these 6 inmates where they might have been named as a suspect, and they found none. The policy violations, the sheriff's office had a policy that prohibits employees from knowingly commencing or maintaining a relationship with anybody who's under investigation, indictment, or arrest or incarceration. And then the laboratory's quality manual requires employees to conduct themselves in a manner that doesn't diminish confidence in the laboratory's competence, impartiality, and operational integrity. And that policy extends to activities both inside the lab and outside the lab. The laboratory determined the analyst violated both of these policies. Without getting into all the details, there's an email exchange where she's quite forward about the fact that if this was discovered, it might affect her credibility as a witness. So having considered all of these things, the draft report is finding, would ask the commission to not find professional misconduct because this does not involve the forensic analysis of physical evidence. There is no expert or examination or test performed. And we did not find a violation of the Code of Professional Responsibility. The one code provision that might apply says that an analyst shall report participation in a case where there's personal related conflict of interest. There's just been no cases identified for which she might have a conflict of interest. Unfortunately, she voluntarily engaged in conduct knowing it might affect her credibility as a witness, but that's, for her, it's a consequence to her employment, but we don't find it's a violation of the code or constitutes professional misconduct. This corrective action has kind of been updated. It's complete now. They went back and a third-party laboratory, NMS, reviewed her work for the past 6 months and found no issues with her work whatsoever.
That just came in yesterday, the update from the lab, and we will include that update in the corrective action section. We looked at it in detail and it's clearly poor judgment. And had she worked on any cases involving any of the people that she sent commissary money or involving this individual, I think there would have been a finding. And it clearly is a violation of the sheriff's office policies. but at the same time, we need to sort of stay within the bounds of what our rules focus on and what the statute focuses on, and that's professional negligence, professional misconduct, and those clearly involve forensic analysis and expert examination or test on physical evidence for the purpose of connecting that evidence to a criminal action and related testimony. That's our jurisdiction for, you know, the forensic analysis piece. And then the code just isn't, there's no broad prohibition in the code against engaging in particular types of relationships more generally, like the sheriff's office procedure. So, you know, we recognize and concur with the sheriff's office that it was poor judgment, and it looks like, based on everything they sent us, a violation of their policy, but we did not see a code violation because ours is specific to a case where there would be a conflict. And, you know, sometimes people have to not participate in forensic analysis because maybe, you know, there was a home invasion involving a relative or a neighbor and people have to recuse from the work. And this would certainly be that. But they didn't find any cases with these individuals associated as defendants, so.
I think the only thing that I would say about this is, while it may not be a violation of our rules right now, I feel like at some point in time that may be something we should take up. That if you are having a relationship with somebody that, like Jefferson County, that you need to at least notify, because I do think that that has a perception of impropriety in some way, shape, or form. So, for example, in my office, if people are dating in my office, I need to, like, I know there are other DA's office like this, that we need to know so that we don't put people in compromising situations or put people in supervisory positions over other individuals. I think the rule at Jefferson County is something that we may need to look at in terms of having as not an action, something that's actionable, but something you at least need to notify your employer of at some point in time, because this does look really bad.
I think we can put that on the agenda for next time. We just can't talk about it today because it's not on the agenda for today, but we can add that item. Can y'all make a note just for next time? And that would be a broad consideration of disclosure regarding relationships generally. So we can look at that.
All right, is there a motion to adopt the draft investigative report subject to non-substantive revisions by staff?
So moved.
Motion has been made, second.
Second.
Second's been made. All those in favor say aye.
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 Opposed? Motion carries. Item number 10 is an update from the investigative panel in complaint number 25.77.
I think you're gonna need to bring that mic way closer, Robert, for anyone to hear you, because it's kind of,
We're preparing to meet with the panel soon. We've kind of started on the report, set forth the facts and the issues, and then we're gonna meet with the panel and discuss, you know, our recommendations and observations.
so for panel members, we'll be sending out a request for scheduling soon.
Okay. Any further comment? Item number 11 is an update on the statewide firearms working group.
Since our last meeting on February the 23rd, staff held a meeting with the Method Conformance Working Group. This is the group that's looking at all the SOPs for firearms across the state and see if we can find a general consensus of how to approach it the same. And we decided to work with the authors of the NIST Firearms Process Map creators for like a detailed and organized approach to that SOP review. Then on March 3rd, we adopted our last outstanding blind verification policy, Corpus Christi PD. March the 9th, we were supposed to meet with the creators of the NIST process map, but it was canceled due to the conflict in the Middle East. The person that we were gonna meet with lives over there. And it got rescheduled for April the 8th, and then that day, our office and Steve Aston, who's working on this project from the Austin Forensic Science Department, met virtually with the creators of this process process map for an overview and explanation of the way it works and what all the grids mean and the characters in the process map. And this will allow us to have a comprehensive and efficient review. And they've expressed their willingness to assist us throughout the process. In fact, we got an email from them today or yesterday asking how it's going. So it's actively being worked with our group.
And I think NIST has, various levels of NIST have expressed that they are excited about this project and want to help us however they can. So we've been grateful for that.
Any further comment? All right, item number 12, an update for the statewide working group on rapid DNA.
Yeah, so a couple things here. The first thing, I'll just give a quick update. Not much movement from the rapid working group. We met in early March together, and we're still combing through the two primary tasks right now in the group, which is a Texas memorandum of understanding between an accredited crime laboratory and then a law enforcement agency partner. And then the second thing is the guidance that we're looking to issue for sample eligibility, like what samples are actually eligible or suitable to be collected and then ran on a rapid instrument from a crime scene. And just to be clear, there are no instruments or cartridges yet approved by NDIS to do this. So this is really our attempt to, with this working group, to get some guidance in place before those instruments are approved so that everybody's on the same page in Texas. So that's the first part. The second part, Lee alluded to earlier with our little subcommittee that we have for the licensing to discuss a rapid DNA operator license. And we talked quite a bit about the importance of recognition and collection of those types of items, which right now we're looking at things that we would hope would generate single source profiles, so that would be in large quantity, so you could collect enough to allow for essentially duplicate testing in a crime laboratory. So those are really gonna be things like blood, maybe saliva, straw, cigarette butts, things of that nature is where we're kind of looking at that. So the collection aspect and then also the operator aspect of these instruments is important. And they're really similar, like both of those individuals' roles, if they are two different people, the redundancy is important. They both need to understand the limitations of the instrumentation. And so really what we were looking at was we were trying to figure out, would this be for licensure requirements, right? Would this be something that would be more of a technician role, which that exam is a little bit different than it would be for a full analyst. And what we really came to is that these individuals need to take the full analyst track exam, similar to what we would expect from a crime scene analyst. And that seemed to be consensus after a really good conversation. And then the other aspect of the licensure really is that the education and the training aspect, which we will definitely be looking towards developing some sort of curriculum, probably with our partners that we use all the time, and helping to figure out maybe using some information that's already out there from other agencies that have developed modules for training on the use of rapid instruments, and then putting our own touches on it. Did I miss anything, Shelley, or?
I think chances are high that it'll be Texas DPS doing these first, and they're doing the pilots for the booking stations. They're also doing research and providing data to the FBI on evidentiary samples on rapid instruments. So before anything happens, and as Jared said, the FBI still has not approved the cartridges, but if anything happens, there will be a full set of modules for training that I believe DPS is now starting to think about developing. Arizona DPS has modules, so we have something to look at as a reference or a model. Because of the relationships with IFRTI and Sam Houston University, it'll be likely that there'll be a university partnership to make sure that people can take that training efficiently and effectively, but we're still a ways out from implementation, certainly on any of these umbrella MOUs. I think DPS right now is more focused on making sure that the pilot for the booking stations goes well. But we want to get ahead of anything that might be, we don't want it to be rolled out kind of in an unintentional way when it does come time for these rapid instruments to be used. We want to be very clear about how we're doing it. So the group has been doing great work.
Any other comments? All right, item number 13, an update on the Texas Forensic Analyst Apprenticeship Pilot Program.
So for the apprenticeship program right now, there are sort of a couple different tracks happening. One is that the universities that are working on seized drugs and alcohol toxicology and forensic biology, I would say of those three disciplines, seized drugs is furthest ahead in terms of curriculum development, and that is being worked on at IFRTI at Sam Houston. And then alcohol is also in progress, and the way the curriculum is being developed is with input from members of the community who are experts in these areas, and also people in the labs who know what the current training environment looks like and can give input about what would be most helpful for these apprentice positions. In addition to that academic piece, we have asked the labs to respond to tell us what apprenticeship positions they are interested in. What can they most use? Like, do you need more drugs, folks, or blood alcohol, or forensic biology? And the responses to that survey are coming in. They were sent out via the TACLID. So please, for lab directors, if you can fill out that survey as soon as possible. If you have trouble with the survey for any reason, we can help you with that, or we can just accept the answers via email. But we're really trying to understand what people can most use, like which disciplines have the highest need, which ones you feel like you could, if you had an apprentice salary paid for, which ones can you sustain long term, to absorb that FTE salary over time. So we're trying to work with the labs to get a sense of that, and then also to work with them on the timing of these things, because timing is important for hiring, and I think people really want to know, like, okay, in my budget planning process, where might this apprentice or set of apprentices fit in? It is not just, it won't be forever only drugs, alcohol, and forensic biology. There's a need in firearms. There's a need in other areas, maybe even, crime scene or Friction Ridge. The question is, how do we get university partners who really can do a good job of implementing a firearms curriculum? Right now, we know that the chemistry work at SHSU has been there a long time and is robust, and they've done similar training for DPS through state apportioned funds, and UNT, well, the CHI is historically done similar training in the area of forensic biology, but finding a university partner for firearms is something that Peter Stout has been working on, because there is a need in firearms, and we just need to figure out the best place to house that. But it is not that we don't want to do it, it's just that we have to have a partnership to advance it. So right now, I feel like things are going well in the program development front. I don't know if any commissioners who are involved want to add anything to that? Dr. Kerrigan or Dr. Coble, Ms. Zemek?
I would just add that we were successful hiring a full-time director for the apprenticeship program at SAM. We hired Dr. Hinners, who has a PhD in chemistry, but also past experience working in accredited labs in Texas. She worked at the Harris County Institute of Forensic Sciences several years ago, and so she was hired at SAM in March, so just very recently. But she's been working on this project with us as a contractor prior to full-time employment. So I think that we're moving forward at a pretty good pace at this point.
There's an interim charge. The legislature has released interim charges, and one of them is for the relevant committee on the House side to get an update about how the apprenticeship program is progressing. I think Dr. Stout had actually made that suggestion to the Speaker's office, I think because the idea is that we're hopeful that this will get integrated into the base budget, so it's, you know, extended beyond a pilot phase. We don't know when that hearing will be held, but we'll give you all an update when that happens. And then the other issue is that we do have a rule that we had proposed last time that lays out the framework for what's required for labs to participate. And so we will need a vote on that rule. And that's under B on your agenda.
All right, is there a motion to adopt the rule amendments as discussed, subject to suggested non-substantive revisions from the Office of the Governor, Texas Registering Commission staff?
So moved.
Is there a second?
Second.
Second's been made. All those in favor say aye.
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 Opposed? Motion carries. Item number 14.
This is an update on some proposed changes to CODIS access, and I think we were going to get an update from Brady Mills of Texas DPS.
Good morning, Brady Mills, Texas DPS. I appreciate the opportunity to give you an update on this. We've, as a community, have had a lot of conversations about CODIS and access to CODIS for a number of years now. And this particular venture is supported by private laboratories to have legislation that allows them to have direct access to NDIS to be able to place samples in the database. And when we look at that as a community, I think the goal, I think we all agree on the goal. Our goal is to get CODIS samples into CODIS as efficiently and effectively as possible so that that search can happen, so that it can further the interests of public safety. And I think we all agree with that. Legislation, though, is being proposed by a congressman here from Texas, Congressman Hill's office. There's concerns with that with the community. And giving direct access to private laboratories, how that's written is not probably a way to answer the question of promoting public safety. And we've been engaged in this conversation with the law enforcement groups. So all the law enforcement committees have forensic science committees, and those committees are very active in the space. We've had direct conversations with Representative Congressman Null's office. And our position was always, let's further the conversation, let's get the right people to the table, including the FBI, to have a conversation about how to make this happen, and then also highlight some challenges that are with the proposed legislation. That has accumulated into a roundtable discussion that's scheduled next week. National laboratories are well represented, both on the private side and both on the public side, and then laboratories here in Texas are well represented in that invite list as well. So Dr. Stout and myself, we will be part of that roundtable to have a discussion with the community to figure out how to move forward as a community. The other things that are going on is the FBI is very engaged in this. Obviously, they're a very big stakeholder in this as they run the CODIS program. So they are meeting with their state and local CODIS administrators next month to have a conversation about this. And then the lab director, who will be soliciting information from the CODIS community, is going to bring that to the state crime lab directors during the Ask Lab symposium next week or next month as well. So really, having this legislation being offered by the Texas congressman has really helped speed up the conversation, which is actually good for us as a community. So that's kind of where we're at today. Dr. Stout has been very vocal in the space, just from a TACPLAD position. I've had the opportunity to have a couple of conversations in this space as well as representing the Association of State Criminal Investigative Agencies, which DPS is a part of, and then being with their forensic science committee. So there's all I have, unless there's any questions.
The roundtable that's coming up, is that in person or virtual, and can people?
It's virtual, and I don't know about how widely distributed that is, but I can certainly get that to the commission and see if there is the opportunity to view that.
Thank you.
Thanks.
All right, thank you.
Item number 15 is the discussion regarding the American Medical Association's resolution setting standards for forensic toxicology laboratories. Dr. Kerrigan.
So this is just informational at this point. It was just to make sure that the commission was aware that the American Medical Association is putting together a resolution to address potential regulatory changes that would impact forensic toxicology labs, including those in Texas. Essentially, they're asking that forensic toxicology labs that analyze drugs and body fluids follow the same, they call it certification, but essentially they're talking about accreditation requirements as clinical labs in hospitals. And so there's a fairly lengthy document that has been drafted by the AMA that is proposing that forensic labs that do this type of work follow these clinical guidelines, which is somewhat problematic. So we're relying very much on our colleagues, the members of NAME and some of the other professional organizations that have representation in the House of Delegates to educate the American Medical Association on where the forensic toxicology discipline is. It actually has more published standards than many of the other forensic disciplines, thanks to the efforts of the NIST OSAC and also the Academy Standards Board. So this is just to make sure that people are aware of that. And if you,
I think somehow your mic went out. I don't know. Do you want to take it?
I think it's battery is dying. I think it's green at the moment, so I'm pretty much finished. But this was just informational. If anyone has questions, please reach out to me. We have a fairly limited window to get information to the representatives that will be speaking about this to the AMA.
I actually have a question about it. So is it an intentional walking back? In other words, we know that all the standards that we have in place in forensic labs that do this work are robust and more robust than what they're proposing? Or is it just a misunderstanding of what forensic toxicology labs do?
So I think it's an absence of current information on where what the accreditation landscape looks like.
Okay.
It's pretty clear from reading the draft of the resolution that essentially the group really relied on doing internet searches to put together the draft resolution and some of the contextual information. For example, it references ASLAB Lab as an accrediting body, which hasn't existed for over a decade, and cites heavily information from the discipline that dates back to the Houston Police Department crime lab. So it generally shows sort of the lack of relevance, and so we're hoping that we can help educate them so that the resolution that they have at least reflects the current landscape of forensic toxicology and standards, because a lot of work has been done in that area, and we certainly want to reflect that in in the report, but also we don't want conflicting standards to be developed. And, you know, the standards that we have in forensic toxicology far surpass those that exist in a clinical setting, and for a good reason. So this is just informational, but I'm glad to provide more information to anyone after the meeting if you want anything else. Thanks.
It's kind of interesting, they are wanting to have regulation over specimens that they themselves don't analyze, nor would they be able to with the different types of degraded specimens. So,
and the genesis of this was really some of the issues arising from cannabinoid determinations in biological specimens in the state of Illinois. So that's why the AMA is taking this issue up.
thank you.
That whole thing is not reflective of the rest of the country, I think is the problem. It's a misunderstanding that what was revealed in that investigative reporting is the state of play everywhere, and it's not.
All right, item number 16.
So this is just an update on the various forensic development work that the commission staff participates in. We have two accrediting bodies, as you know, ANAB and A2LA, and Lee presents regularly, periodically to A2LA's FIAC meeting to talk to them about the work of the Forensic Science Commission. And we also had participation, as you know, at AFS. There was a rapid DNA presentation that Jared did. There was also a presentation that Robert participated in on the work in firearms. Jared has done talks at the Southern Association of Forensic Sciences and the Mid-Atlantic Forensic DNA meeting. I gave a talk at the Bexar County DA's office last week, as well as at Bodie's annual conference. Brady and I presented to the regional presiding judges, which is always interesting because they're not shy. They have a lot of questions and they are not shy. It's great when we go to those meetings because it also gives, like, if there are miscommunications or misunderstandings with anything, especially about DPS testing, those judges are able to get a direct audience with DPS, so those are helpful. Jared will be presenting at Quattrone, or facilitating a conversation at Quattrone soon. We have the Kale Innocence Conference coming up, which is a big one because there's a major retirement by Centurion Ministries, which, if those of you are familiar with exonerations in Dallas County, the founder of that had a lot to do with some of that big group of exonerations that first came through. So he's retiring and there's a celebration of that happening. I will be participating in the Tarrant County Death Penalty Defense seminar coming up soon. And then Lee is doing a presentation at the ASCLD Symposium with Sarah Chu about transparency in forensic science. I don't think I missed anything, but we definitely get invited to present frequently, both in Texas and at national meetings, and we continue to do that work.
All right. Item number 17, report from the DNA Technical Leader Working Group.
Yes, so we had taken a little bit of a hiatus with this working group so that the group could, along with, so we have a working group that's really a subset of some of the DNA technical leaders across the state, private and public laboratories, to prepare for the meeting that we had at the end of March that was hosted by CHI, which is fabulous. And so we try to do this on an annual basis, at least get together for about a day and a half. So the agenda was packed. We really, and that is present in the meeting materials. If you didn't have a chance to look at it, there was a variety of talks. We were able to hear from Dr. Tasha Hicks from Switzerland about different approaches to interpretation when it regards questions about multiple persons of interest potentially being a contributor to DNA. So that was really cool, and her willingness to share their work product and the way they go about doing that in their laboratory, and then how they would report that as well. And then we sort of moved into some other discussions. We kind of started an interpretation with the subsource questions. We talked about, how we might handle or address issues when we start to be asked, is this profile from blood or is this profile from semen? Like very common questions we might get from investigators or during court. And then we wrapped up the meeting where we really delved into what we're really trying to focus on in the small task group for the reporting and testimony group about giving some guidance for concepts of how we handle difficult questions when it relates to DNA transfer and persistence. So kind of trying to take the similar approach we did with the reporting concepts of having establishing background, providing general information. So we're making some progress on that, and we're going to start meeting again next week. They have an updated draft to work from, and we're really hoping to refine that document and get that out into the public domain soon.
All right.
Thank you.
Any further comment? Okay. Item 18 is Dr. Stout here.
Dr. Stout is not here and there is no update. There will be in July, but the TEFA meets twice a year and winter, summer.
All right. Item 19, consider possible agenda items for next quarterly meeting. Is there anything that any committee member wants the staff to place on the next meeting?
We have the request that Mr. Parsons made earlier to think about a general provision on disclosing relationships, so we'll work on that. And then all the carryovers from this agenda as we typically do.
Okay. Item 20, schedule and location of future panel and quarterly commission meetings, including but not limited to July 31st, 2026, October 23, 2026, January 29, 2027, April 30th, 2027, and July 30th, 2027. Is there a motion to direct the staff to schedule these meetings? Is there a second?
Second.
All those in favor say aye.
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 All right. Item 21, public comment. I believe we have a speaker, Ms. Taylor.
Yes.
And if you could introduce yourself, and the comments are to 5 minutes. We'll let you know when there's a minute left to go.
Good morning. Good morning, everyone. My name is Rhonda Taylor, and I thank you for allowing me to speak. I would like to present an informal policy proposal and maybe one day becoming a bill. The purpose of this proposal is intended to encourage discussion, serve as a future consideration, and be one day enacted by the legislature of the state of Texas. The proposal title is Mandatory Accredited Forensic Response in Fatal Hit and Run Cases Act. The definition of a fatal hit and run incident means a motor vehicle accident resulting in death, where the operator leaves the scene in violation of state law. Accredited Forensic Science Unit means a forensic investigation unit accredited by a national recognized accrediting body. Why it should be mandatory? To require law enforcement agencies to submit physical evidence within the jurisdiction over a fatal hit and run incident within 1 to 7 days after a 24-hour report of death to an accredited laboratory. This would avoid misconduct, penalties, and/or corrective actions for non-compliance when intentional withholding and failure to submit forensic evidence. Why it matters? In my research, I didn't find any uniform mandate required agencies to use accredited forensic science labs or certified investigations. Preferably, this proposal could ensure accountability to law enforcement, death investigations, and to make a faith effort to identify the suspect, prove innocence, promote public safety, gain public trust in criminal investigations, and uphold integrity of the justice system in cases involving loss of life. This is important to me because this is what happened to my son. My son was killed on October 2nd, 2022. He was a 38-year-old mentally challenged pedestrian who knew how to cross the street. Unfortunately, he was struck by two motor vehicles. The first vehicle was a hit and run, failed to stop and render aid. The second vehicle stopped and called 911. In my research, I am a law school graduate, 2021 at Purdue Global. So in my research, I found multiple vehicle pedestrian cases. Forensic science analysts can reconstruct, meaning to rebuild, recreate what happened during the crime or incident, such as analyzing things like skid marks, vehicle damages, road conditions, and determine speed directions, paint transfer. Of course, nobody was charged for killing my son. I believe no charges were not filed because there was no forensic submission. These actions also led to non-compliance to the death certificate reporting under Body Statistic Guidelines number 41 on your death certificate, particularly the requirements to describe the injury mechanism of the specified vehicle type in motor vehicle incidents. These actions also prevented my family from knowing which vehicle actually killed my son. And it also hindered the family from filing a wrongful death claim. My family is still seeking justice regarding the concealment of the facts surrounding how my son was killed. Kevin Roger Gordon II lost his life on the city roadway in Killeen, Texas on October 2nd, 2022. Thank you, and God bless.
Thank you. Are there any other comments? Any public comment? Any comments by commission? All right, hearing none, is there a motion to adjourn? So moved. Is there a second?
Second.
All those in favor say aye.
Aye.
Opposed? Motion carries. Meeting is adjourned.